I didn't grow up wealthy, and I definitely didn't grow up imagining I'd ever own land big enough to have its own weather. So when the attorney called and told me I'd inherited a 900-acre lake ranch, I assumed there had to be a mistake. My late uncle was a quiet, private man, no social media, no neighborhood gossip, no HOA meetings. He lived off-grid, paid his taxes early, and trusted paperwork more than people. What he left behind wasn't just land, it was freedom. A massive freshwater lake, rolling pasture, tree-lined ridges, and, as I would soon discover, a ticking legal time bomb. The first red flag appeared before I even stepped foot on the property. Along with the deed transfer documents was a thick envelope labeled HOA correspondence, ongoing matter. That alone made my stomach drop. An HOA on a 900-acre ranch? As I flipped through the letters, the tone shifted from smug to threatening. Unauthorized construction. Non-compliant land use. Final notice before enforcement. All signed by the same name, Marilyn H., HOA President. The last letter claimed the HOA had assumed stewardship over a portion of the land due to long-term neglect. That's when I realized something was very wrong. When I finally drove out to the ranch, the scope of the problem became impossible to ignore. Near the north edge of the lake, on land clearly marked in my uncle's old survey maps, stood a 3-story luxury mansion. Stone facade, wraparound balconies, private dock, manicured lawn cut into the hillside like it had always belonged there. It hadn't. I pulled over, got out of the truck, and just stared. Someone hadn't just trespassed, they'd built a palace. And judging by the fresh landscaping and luxury vehicles parked out front, they were living very comfortably on land they didn't own. That's when Marilyn showed up. HOA polos, clipboard tucked under her arm, smile sharpened to a point. She welcomed me like a guest, not an owner, and immediately launched into a rehearsed explanation about community agreements and mutual understandings that supposedly allowed the HOA to manage unused land. According to her, my uncle had verbally agreed years ago to let the HOA develop that section of the ranch. There was just one problem. My uncle documented everything. And there was no agreement, verbal or otherwise, on file. When I calmly told her the mansion was built entirely on inherited property and that construction had never been authorized, her tone changed instantly. The smile vanished. She warned me not to cause trouble, claimed the HOA had lawyers on retainer, and insisted the house was protected by years of occupancy. Then she made her biggest mistake. She told me, point blank, that fighting the HOA would cost me more than the land was worth. She had no idea what she was about to lose. The very next morning, I sat at the long wooden table in my uncle's old study, surrounded by dusty file boxes he'd labeled in thick black marker. Inside were decades of surveys, tax receipts, zoning maps, and correspondence, everything meticulously organized. Within an hour, I found the original boundary survey stamped by the county surveyor, updated twice over the last 15 years. The mansion sat nearly 600 feet inside the ranch's northern boundary. There was no overlap, no easement, no shared use clause. It wasn't even close. Whatever story Marilyn had been telling the HOA board, it wasn't grounded in reality. I took the documents straight to the county planning office. The clerk raised an eyebrow the moment she pulled up the parcel number. According to their records, no building permits had ever been issued for any structure on that portion of the land, let alone a 3-story luxury mansion. Even worse, the construction plans on file for Marilyn's house were approved for a different lot nearly half a mile away inside the HOA's actual subdivision. Somewhere along the line, either by mistake or design, the mansion had been built completely off-site. The clerk printed everything and quietly suggested I speak with a land use attorney. Before I could make that call, the HOA made its move. I received a certified letter accusing me of harassment, claiming I was interfering with HOA property and demanding that I cease all intimidation efforts. They even threatened fines for unauthorized inspections of their land. The irony was almost impressive. Marilyn clearly believed confidence could override deeds and surveys. She was counting on intimidation, on the assumption that I'd back down rather than challenge an entire association. Instead, I hired a surveyor and a lawyer. Within a week, bright orange stakes lined the edge of the lake, each one clearly marking the ranch boundary, running straight through Marilyn's manicured lawn, her dock, and the lower level of the mansion itself. When the surveyor finished, he looked at me and said, "They didn't just cross the line. They ignored it completely." My attorney sent the HOA a formal notice of encroachment, unlawful construction, and quiet title demand, attaching copies of every county record. Marilyn showed up at the ranch that evening, furious. She accused me of fraud, threatened to bury me in court, and claimed the HOA had been using that land for years without objection. I reminded her, calmly, that use without ownership doesn't become ownership just because someone built a bigger house. Her voice cracked when I mentioned the missing permits. She stormed off, still insisting the HOA would win. What she didn't know was that the county had already opened an investigation, and the next letter she received wouldn't be from me. The first official notice arrived faster than I expected. Less than 10 days after the survey stakes went in, the county mailed a notice of violation addressed directly to Marilyn. Not the HOA, not a shell company, but her personally. It cited unpermitted construction, improper land use, and development outside approved parcel boundaries. The letter ordered an immediate halt to any further work and scheduled a mandatory inspection. When I heard about it, I didn't celebrate. I knew this was the moment when people like Marilyn stopped bluffing and started panicking. The inspection day felt surreal. 2 county trucks rolled up while Marilyn stood on her balcony, arms crossed, trying to project authority. The inspectors walked the property with my surveyor's maps in hand, measuring distances, photographing the foundation, and tracing utility lines that ran across my land without a single easement on file. The private dock, the retaining walls, even the driveway cut through protected shoreline buffer zones. One inspector shook his head and muttered that he'd never seen a mess this big tied to one house. By that afternoon, the violations had multiplied. The county flagged environmental breaches, including illegal shoreline modification and runoff into the lake. The water department confirmed the mansion was tied into utilities using permits issued for a completely different address. When Marilyn tried to argue that the HOA had community authority over the area, the lead inspector shut her down immediately. HOAs, he explained, don't outrank county zoning law, and they certainly don't rewrite property boundaries. That night, the HOA board called an emergency meeting. For the first time, Marilyn wasn't speaking as a confident president, but as someone desperately trying to control a narrative. She claimed I had tricked the county, accused me of weaponizing bureaucracy, and insisted the house would be grandfathered in. But when one board member asked why the permits listed the wrong parcel number, the room went silent. The HOA's attorney, who had joined by video call, finally spoke, and asked Marilyn a question she couldn't answer. Did you know the house wasn't on HOA land when it was built? The next morning, Marilyn was served again, this time with notice of escalating fines and a compliance deadline. Every day the mansion remained out of compliance, the penalties would stack. The county didn't care about HOA politics or personal grudges. They cared about land records, permits, and laws, and every one of them pointed in the same direction. What Marilyn had built wasn't just illegal. It was indefensible. And court was no longer a possibility. It was inevitable. The lawsuit landed hard and fast. My attorney filed for quiet title, ejectment, and damages, naming both Marilyn and the HOA as defendants. The county violations were attached as exhibits, along with certified surveys, tax records, and permit histories. When the hearing date was set, the HOA board scrambled to distance itself from Marilyn, issuing a statement that her actions had been taken in good faith and under assumed authority. That phrase alone told me everything. I was about to watch a group of people quietly push their own president under the bus. In court, Marilyn tried to reclaim control. She testified first, confidently describing years of open and notorious use of the land, claiming my uncle had abandoned it and that the HOA had stepped in to maintain it for the community. The judge let her speak without interruption, then asked a single question. Why, if the HOA believed it owned the land, had property taxes been paid exclusively by my uncle for over 2 decades? Marilyn stammered. There was no answer that didn't expose the lie. My attorney followed with the documents. One by one, each claim unraveled. The survey maps showed the mansion's foundation squarely on ranch land. The permit records showed approvals tied to a different parcel. The county inspector testified that the violations were among the most severe he'd seen tied to a residential build. Even the HOA's own attorney admitted under questioning that no easement, transfer, or development agreement had ever existed. At that moment, Marilyn stopped looking at the judge and started staring at the table. The turning point came when the judge addressed Marilyn directly. He explained, calmly, almost patiently, that building a structure does not create ownership, no matter how expensive or permanent it feels. He rejected the HOA's arguments outright and granted my request for quiet title on the spot. The mansion was legally declared an unlawful encroachment. Marilyn's face went pale as the judge ordered her to either remove the structure or compensate me for its full value, along with damages and legal costs. As the gavel came down, the HOA board members avoided eye contact. Marilyn didn't speak. The authority she'd wielded for years evaporated in a single afternoon. The court had done what intimidation never could. It reduced the entire scheme to what it really was. And while the ruling settled ownership, it didn't settle consequences. Because the final order wasn't the end of the story, it was the beginning of Marilyn losing everything she thought she owned. The deadline the judge set was brutal in its simplicity. Marilyn had 90 days to resolve the encroachment, either by purchasing the land at court-determined market value, paying all damages, or by removing the mansion entirely and restoring the shoreline. The county fines were still accruing daily, and the environmental violations carried penalties that dwarfed what most people ever see in a lifetime. The house that had once symbolized her power inside the HOA had become a financial sinkhole she couldn't escape. Behind closed doors, the HOA board fractured. Emails leaked showing board members arguing over who knew what and when. Several admitted they'd questioned the location of the build years earlier but trusted Marilyn's assurances. Now, faced with potential liability, they voted to terminate her presidency and revoke her indemnification. Overnight, Marilyn went from protected leader to personally exposed defendant. The HOA publicly disavowed the mansion, calling it a private matter, a move that left her completely alone. The forced sale came next. Marilyn couldn't afford to buy the land, cover damages, and satisfy the county, all while fighting multiple lawsuits. The court approved a judicial sale of the mansion, with proceeds split between penalties, restitution, and my awarded damages. Watching the "for sale by court order" sign go up at the end of that once perfect driveway was surreal. The house sold at a steep discount, its value crushed by its legal history. What remained barely covered her obligations. When the dust settled, I received the final accounting. The damages, legal fees, and compensation more than covered my costs, and then some. More importantly, the title to the entire 900-acre ranch was reaffirmed without challenge. The county supervised the partial shoreline restoration, and the illegal dock was removed. What had once been a symbol of entitlement was reduced to a cautionary footnote in land records and court filings. I still walk that stretch of the lake sometimes. The grass has grown back, the water runs clear, and the land feels quiet again, like it belongs to itself. Marilyn's mansion is gone, the HOA keeps its distance, and the ranch remains exactly what my uncle intended it to be. Power, I learned, isn't about who shouts the loudest or builds the biggest house. It's about who owns the truth, and has the paperwork to prove it.